Hello, how are you doing? Hope you're good. Hope you're fine. You're welcome to Lawyers Infohub. It's a pleasure to have you here. So today we're looking at the plea of Alocutus and forms of penalty. If you're seeing for the first time, your host on Lawyers Infohub, a platform where we teach law, we try to simplify it to the most um, beautiful and simplified way for ease of understanding. We bring in people to share their experiences with us, aimed at helping you to become a better law student, a better lawyer, and a better person to the society, to become excellent in your work as a lawyer. So today we're looking at the plea of Alocutus and forms of penalty. This is under our criminal law series. After the court has heard a matter in the against an accused person, and the court has sentenced or has convicted the accused person. Most of the times, by way of procedure, the court allows that person to just speak. That is what we call alocutus. Alocutus is a plea of mercy, is a plea for the court to mitigate, the punishment or sentence to be given to that person, that accused person who is now convicted. So in the court, when the court has finished, reading out his judgment and has convicted the person, the court gives opportunity to him or her. That is where you now see such persons or such accused person or now who are not convicted to start pleading to the court to have mercy. My Lord, I'm a first time offender. My Lord, I'm the first child of my parents. I'm the only child of my parents. I've changed since my incarceration, since my arrest. I've done a new leave. I'm now a better person. This is my first time. I've never committed any offense before. My Lord, I have three children. I have a pregnant wife. My Lord, I have an aged mother, and I do not have siblings. My mother depends on me for her source of livelihood. Things like that. That's when we begin to hear all sorts of a plea for the court to, you know, have mercy on them by way of reducing or mitigating the sentence to be given to that person. So when this happens, the court uses its discretion, to know what to do. Now, where peradventure the court does not call for a plea of allocated, the courts usually give the opportunity to the person who has been convicted to say one or two words to the court. Most of the times, you just see them crying, just kneeling down, begging. They're just overwhelmed by what is facing them. You know, um, Also, when the court asks for this plea of allocutus, after the person must have spoken, the court will ask the prosecution about the criminal record of the convicted person. This is now where the prosecution begins to state whether the person is the first time offender, you know, uh, this is to help determine the appropriate punishment in line with the law. In line with the law. It's also very important to note that a plea of allocutus, many a times, many people say that it does not really have much weight. For me, a plea of allocutus can really help to mitigate the sentence of a person. So it's not a waste of time. It's not a waste of time. Sometimes courts consider it. Some other time, the court just goes on to sentence the person according to what the law, the maximum punishment. Some other time, depending on the court, it also helps to mitigate whatever that sentence would be to something much lesser. Now we're going to look at the forms of penalty. Now, when the court has finished convicting the person has been given an opportunity to, to plead, to do his allocutus, and the court will now proceed to sentence the accused person who is not convicted. So not sentence him, 2 years imprisonment, 3 years imprisonment, life imprisonment, depending on whatever it is. So we're going to look at the forms of penalty. Now, this, that the court can give in a criminal proceeding. So the first one is death sentence. Death sentence is usually for capital offenses. I know if it's a capital offense, the court does not have any discretion. So after the accused have been found guilty of a capital offense, the court makes its pronouncement of, the sentence of the court upon you is that you will be hanged on the net until you be dead, and may the Lord have mercy on your soul. Excuse me. So this death sentence, when it is, pronounced, there has been some argument as to whether it must conform to these exact sentences I read. What the Supreme Court has said, that it must align, with the stipulated terms as by the Criminal Procedure Act, and it must be recorded verbatim. Although the court is not bound to comply strictly with the form, although it is desirable. So, but you see, most times you see the court stating it. If it's a death sentence, that is, this is the sentence of the court upon you, that you be hanged on the neck until you be dead, and may the Lord have mercy on your soul. Um, you must also note that death sentence is also, however, subject to the constitutional powers of the president or the governor. In that instance, it's also very important that when someone is below the age of 17, you know, death sentence cannot be passed on the person, because it is assumed that the person is not yet an adult. Persons under the age of 17, the death sentence cannot be passed on them. So where the person has been convicted of a capital offense, the person is kept on detention at the pleasure of the governor or the pleasure of the president. Now, it's also left for the court to ascertain the age. Sometimes the age of an accused person is always called into question. The court can look at the record of the proceedings, calling of evidence as to verify the age of the person, or calling medical examinations to ascertain the age of this person, whether he's still a minor or is an adult. And remember, where there's a pregnant woman involved, you cannot pass a death sentence on the pregnant woman. Rather, she can be sentenced to life imprisonment. Uh, So when a woman is pregnant, you can't pass a death sentence on her, because I assume she's carrying a child. You're passing death sentence on two people. So what it's converted to life what imprisonment. Now another type of penalty the court can give is that of imprisonment. Imprisonment is almost in nearly all the cases, and it can be with or without hard labor. Where it is with hard labor, it will be specified. Where it is not with hard labor, it will also be specified. Another form of penalty is fine. Sometimes you've seen where the court convicts someone and gives the person an option of fine. It doesn't mean that the person is no more an ex-convict. So where there is an option of fine, the court will state out what that fine is and the condition, if there are any conditions. And also the court must look at the ability of the person to pay. Sometimes a person is given an option of fine and he cannot pay. So the court considers the ability of this person to be able to pay whatever fine it is that the court wants to award. So another form of penalty is caning. Caning can be added to the imprisonment term, or it can be separate. But it should not exceed 12 strokes of the cane, and it shall be a light rod. The law has made provision for, it's 12 strokes, and it should be a light rod or cane. Now, a woman cannot be subjected to caning. A man of uh, 45 and above too should not be subjected to caning. When a person is already under death sentence, there's no need to add option of caning to him. Now, we have another form of penalty called hardy lashing. Hardy lashing is usually available in the north. It is meted to those who are subject to the Islamic faith, they have been convicted of cases ranging from immorality, adultery, alcoholism, and all of that, defamation. The essence of hard lashing is directed towards subjecting that convict to disgrace, to do rather than infliction of pain. The idea is that you want this person to be disgraced so that the person will know that what he or she did is not good. So we also have another form of penalty, which is deportation. This applies to non-Nigerians. When non-Nigerians are found to be guilty of offenses, one of those considered penalties considered against them or for them at the end of their case is deportation. They are then deported back to their countries, where they originally are from. So where a foreigner is in Nigeria and committed an offense, so deportation can be one of those ways of punishing that person. Now we have compensation and restitution, where, for example, someone has stolen, and the court can order that that thing that has been stolen be restored. And it should be restored to the owner. So, and it is a form of alternative dispute resolution mechanism. So, where someone steals something and be caught, and at the end of the day, what has been stolen can be recovered and restored back to the owner, is a form of is a restitution, and is a form of alternative dispute resolution, because if it is restored, the issue between the parties have been resolved. you know Rather, it focuses on repairing the harm done, rather than just punishing the offender. Now we also have another form of penalty, which is forfeiture. Most times economic crime cases, you see where some will be ordered to forfeit properties acquired illegally to the government. Excuse me. So it could be maybe forfeit the properties acquired, the monies and all of that to the government in this instance. We've seen the cases of EFCC, ICPC and all of that. They order, or when there's a kind of a plea bargain, the court to, there'll be to be structured in such a way that the person forfeits some large sums or part of what was illegally acquired to the government, or back to the society. So these are some of the forms of penalty available in our Nigerian jurisprudence, under the criminal law setting. So we've talked about a plea of Alocutus. What is a plea of Alocutus? We say that it's a mitigating factor in terms of sentencing, where the court calls an accused or a convicted person, to speak to the court. The person that starts asking for mercy, pleading for mercy, and if the court considers it, it can affect the sentencing. And we see that even peradventure, when the court does not call for a plea of Alocutus, it does not render the judgment of the court invalid. Look at the forms of sentencing. Look at the sentencing that when the court has convicted the person, the next thing is sentencing. Look at what are the forms of penalty. Look at the death sentence. We said a child of 17 cannot be sentenced. Someone less than 17 cannot be sentenced. We looked at a pregnant woman cannot be sentenced to death. Rather, it can be converted to life imprisonment. We looked at imprisonment. We looked at fine. We looked at forfeiture. We looked at caning. We looked at fine. We looked at adulation. We looked at deportation. We looked at forfeiture. We looked at restitution, compensation and restitution as an alternative dispute resolution mechanism that can also be used as a form of penalty. I hope you've been able to learn something today on the plea of Alocutus, what it's all about, and the forms of penalty we have under the Nigerian criminal system. So I just hope you've learned something. If you have any question, please drop it. We will respond to it accordingly. We have other contents on the channel, over 200 contents that are very beneficial to you. So you can go through the channel, check them out, look at them, watch the videos, drop your questions if you have any. We will attend to it. Thank you very much. And do stay safe.